Good afternoon and good evening and good morning here in New York. We're welcoming colleagues and partners in Europe, Africa, Asia, and the United States to this webinar, which will present to you the first ever research on legal protection for apes in their range states, carried out by our partner Legal Atlas. I'm Sebastian Naidu, Global Media Director at the Arcus Foundation, where our work is rooted in a belief that respect for diversity among peoples and in nature is essential to a positive future for our planet and all its inhabitants. Thank you for joining us for the next 70 minutes. Your panelists are in 3 different time zones, so please bear with us if you experience short delays as our speakers hand over to each other. We aim to keep the presentation to about 40 minutes, allowing us 20 minutes for questions and answers at the end. We'll take questions throughout the duration of the presentation using the Q&A button you see at the foot of your screen. Please submit your questions mentioning your name and organization, and our panelists will make a selection of those most representative. We'll be recording the webinar and we'll make the replay online available in the coming days. So our panelists today are Adam Philipson, Program Officer in the Arcus Great Apes and Gibbons team, Maria Pascual, co-founder and Director of Legal Atlas, and James Wingard, co-founder and Legal Director of Legal Atlas. I'll hand over to Adam for more insights into our Great Apes and Gibbons program and to lead us for today's presentation.
Thank you, Sebastian. Yes, welcome everyone, and thank you all for taking the time to participate in this session, despite how early or late it is for some of you. Just to reiterate what Sebastian said, we apologize for the timing. We wanted to find an hour that would suit people on 4 continents. My name is Adam Philipson, and I'm the Program Officer at the Great Apes and Gibbons program here at Arcus Foundation. And so before we move ahead with the Legal Atlas presentation, I just wanted to contextualize this work for you in terms of the Foundation's own goals and strategies. The ultimate goal of the Great Apes and Gibbons program is to achieve the conservation and respect for both great and smaller apes. We do this by trying to ensure that viable populations are protected from extinction, living in habitats that are sustainably managed, and that this is integrated with economic development objectives. That there is an international commitment to effectively support the captive care of great apes in sanctuaries, not tolerating their use in entertainment or medical research. We want to do this by improving the respect and value that global populations have towards great apes and gibbons. We fundamentally believe that apes have intrinsic value and that there's an umbrella species protecting them or safe habitats and other species within their range states. You'll see some of our specific strategic goals on the current slide. And as a donor that funds both conservation and captive projects, the trade in apes is relevant to all of these strategic goals. When we look at the threats to ape populations, wildlife trade is often identified as being a significant driver of population declines. Despite this, however, there seems to exist a lot of uncertainty as to the extent and dynamics of this trade, with assumptions and conjecture informing decisions about how to engage with the issue. Arcus has been grappling with how best to support activities that relate to the trade for a number of years. We've been making kind of field-focused grants, looking at trade routes, for example, understanding the source of apes in captivity, or gathering information on criminal networks. But from 2017 onwards, we funded a number of pieces of work focused on legal aspects. This was predominantly as a means of educating ourselves more fully around the issue, but also educating and supporting the community that we work with. The current grant that's going to be presented to you today came out of this, and the results of that project will form the content of the presentation. Our hope is that at a broad level, understanding and disrupting the trade will contribute to some of those strategic goals you see behind you, in front of you on the slide. Legal Atlas will introduce themselves, but my overview is that they specialize in creating legal intelligence from legal documents and using that to inform a dynamic experience that those of us who are non-specialists in the field can then understand and use. Now, our hope from the project was that this would deliver really useful and actionable information around the issue of the illegal trade in apes, and that these tools and this learning would then help Arcus and you, its grantees, our grantees, the broader movement, in whatever ways is most useful for you. By accessing and kind of comparing the similar legal content across borders, across languages, and across cultures, we can understand how national laws and the management of the trade changes from one place to another. And it was this outcome that Arcus felt Legal Atlas was perfectly placed to deliver. Now, the analysis of legal gaps, kind of conflicts and levels of compliance that you're going to see in a moment is limited to 17 ape range states. So it's not a completely exhaustive list. And the reason those countries were selected is because they contain Arcus priority landscapes. Those are the ones that we've selected for long-term support ourselves internally as a foundation. So bearing in mind that there are some gaps, there was a reason that we as a foundation made to restrict the way that the analysis was undertaken. Legal Atlas themselves will go into the details of how this has been disseminated, but we wanted to also say that those times it has already been disseminated, certainly over the last 12 months, it's been very, very well received. And one of the objectives of this presentation today is just to ensure that we continue to disseminate it to as many audiences as possible, and that the tools and associated resources can help you in the field and in our range states better position themselves in your own trade-related interventions. There's one kind of final comment I'd like to make quickly before the presentation starts. This is just in reference to a lot of recent media attention around national parks, the management of national parks, and engagement with communities. And as a donor that has a social justice program, as well as a conservation program, and a number of our grantees who work at this interface, we all know that when laws are misapplied in countries of weak governance, it can be at the expense of these communities around national parks and ape habitats. So not only do we need to think about how laws can be improved, but we also need to think about how the legal protection of apes can be done in a way that isn't at the expense of the human rights of local communities. On that note, I'm now going to hand over to Legal Atlas and to Maria. I really hope you find the presentation as useful, as informative and enjoyable as we've done, and as we've heard a number of our partners have done already. As Sebastian said, we'll have an opportunity for a short question and answer session at the end. Yeah, thank you once again from Arcus, from the panelists, and from the movement more broadly for taking the time to be with us this morning to help us think through some of these issues. I'm now going to hand it over to Maria.
Thank you, Adam. Hi, everybody. This is Maria from Legal Atlas. And before jumping into the results, just some brief information about us. We're an organization that are promoting smarter laws for a smarter planet. And we started our work in 2012. And since then, we have been implementing research projects and consulting contracts, all building and creating content for our online legal intelligence platform. That platform is trying to leverage latest technologies in GIS, visual analytics, artificial intelligence to ease the access and understanding of law across jurisdictions and language. So for every one of the research projects we take, like the one that's sponsored by Arcus Foundation, we put together a multilingual global team and implement the project. And what we do is to develop a common methodology to compare law across the globe that can be truly be dedicated to several of the challenges we are facing now, environmental challenges, but also economic challenges or financial ones. So as a brief summary of this project and the research scope, the assessment was targeting 22 species of apes, including all 7 species of great apes and all 15 species of gibbons. As you may all know, all these species are listed on the Appendix 1 of CITES Convention as species treated with distinction. The geographical coverage, Adam just said that we limited to 17 out of the 31 range states, and trying to create these synergies between this new legal knowledge resource and field presence of Arcus partners. Because this project was focused on law and not enforcement issue, the object of the study is really legal documents and law. What we wanted to get is a comprehensive understanding of 2 things, of how countries are regulating these 2 things. The first thing is how wildlife is being moved from the wild to the end consumer on one hand, and then in the other hand, we wanted to understand also how it's regulated the way that money goes back from the markets to the wild. So in order to do that, we collected more than 300 laws. That is more or less 20 laws per country. And as you can see in this list, we did not limit it to environmental or wildlife law, but study transportation law, media law, phytosanitary law, and any regulation that we were finding linked to wildlife trade issues. Results of the project are public in 2 fashions. First, all sets of laws are available at the Legal Atlas online platform. And in the last part of the presentation, Jim is going to provide a demo on how you guys can access all this material. And we feel confident that they should provide a good foundation for all the organizations at the country level that are involved in wild management or enforcement issues, or even are involved in some legal reform that is seeking to enhance the protection of apes and gibbons. So apart from the Legal Atlas platform, there is also an almost 200-page publication that is compiling the individual profiles for all the 17 countries studied. It can be found both in the Arcus and the Legal Atlas websites, and we created also a dedicated URL for the report that is right now on your screen. Perfect. So in each one of the country profiles in the publication, we compile all this kind of information that is listed here, from range distribution of domestic species to the legal powers of the enforcement authorities. But for today, we are gonna select just 2 areas of the study, the ones marked in red, domestic protection and offenses and penalties, because they are providing us good examples on the power of comparative analysis to get best practices and lessons on how to improve the law. So we are gonna start the presentation targeting a common assumption in the wildlife conservation community. There is the idea that once a country has joined CITES, Appendix 1 and Appendix 2 species acquire automatically domestic protection. But the reality is that CITES matter, but it's domestic law that matters at the end. And once a specimen has crossed the border, it is a national list of protected species what is acting as the primary trigger for many management and enforcement measures. So CITES implementing laws do it as well. So the initial research question for us was to analyze this list of protected species and CITES implementing laws in each one of the 17 countries. So, and the goal was documenting which one of the 22 species of great apes and gibbons were part of those lists and were receiving truly domestic protections. And these are the results that we are summarizing in this visual. So here on the left, we can see the 22 species being studied. And then across the top, you can see the 17 countries. We organize the countries based, it's a little small here, but based on the year where the regulation or law listing the species were approved. And we try to allocate on the left the countries with oldest legislation, and on the right, the countries with the newest legislation. So this little circle indicates that the species is native to the country, and then the blue square is indicated when a species is part of the national list of protected species. So when both elements overlap, we are in front of a species that is both native and protected, right? That is what, like the goal of the desired situation. So from this visual, we learn that our sample of countries is showing us up to 4 different situations or approaches. So first, we see the worst case scenario in these countries that I'm just kind of highlighting, where we can see circles that are not overlapping with blue squares. That means that some native species are not listed as protected domestically, even though the countries are CITES signatories. So these countries are Cambodia, Laos, and Vietnam, and are showcasing well the wrong assumption I was talking about, because there is a clear gap here to close. Then we have other countries, right here we can, Cameroon, Uganda, where there is total coincidence between a species being native and a species being protected. And in those countries, there's no gaps that we can identify. But we saw another situations, apart from this second scenario that was the expected one. So then we see another group of countries that is granting protection not only to native species, but also to some others that are not native. So you can check, for example, the case of DRC, yeah? That is protecting the entire taxa of gorillas, even though only the eastern one is native. The same is applying to China here. That is extending protection to all given species, even though only 5 are native. So these countries that start showing as a different policy approach, right? A policy approach that can be guided in some cases because countries may be transit countries for non-native species, or maybe our policy approach is also based in that the fact that this option, it's easing enforcement because it's avoiding the challenge that carries the need for a species identification when you need to present evidence in court. So basically countries like DRC or China are showcasing an area of opportunity for a smarter legal design around wildlife conservation. Lastly, we found these 3 countries where you can see all species in blue, all species protected, that are bringing this China or DRC approach to the and we see Peninsular Malaysia, Guinea, and Tanzania. They are countries on the right of the visual, so we are seeing this as a more recent trend. And what they are basically doing is or transposing CITES international level protection into domestic protection, right? Independently if the species is native or not. So basically, based on that visual and results, we can say 3 things. The first thing is that since as a species cross borders, the reality of enforcement underscores how the protection of a species need to be embedded in national legal frameworks and cannot be assumed, right, solely by a country being CITES a member. And second, that the absolute minimum or the bottom line should be for countries to include in the national list of protected species all native species of apes and gibbons. But lastly, the more desired situation shown by these recent trends show us that expanding protection to non-native species is a strategy for countries to consider because it's really adding strength in enforcement and prosecution. This other visual is using the value chain approach. Here on the top, we can see key activities in the value chain from the wild to the market, including take, transportation, processing, storage. Here, countries listed on the vertical. So this value chain approach is used to identify gaps in respect to what it should be a comprehensive criminalization of acts involving wildlife illegally taken, right? So what we want to see is like from the wild, if I capture live chimpanzees and I move it across the value chain through the market, we wanted to ask which one of the activities are mentioned specifically in law as an offense. So what we can see is that all countries have offenses to tackle illegal activities related to take, right? We see all in gray, trade, and import and export. There are three more traditional activities capturing legal attention in wildlife legislation. But outside these core offenses, other acts involving also critical aspects along the value chain, like the processing or advertising or exhibition, tend to have specific offenses written in law in several of the countries. So if we were to do the same analysis for drug offenses, we would probably see all squares being filled in. So this visual is a good expression of the fact that we do not treat wildlife crimes with the same sophistication and seriousness that we do with other areas of crime. And the visual is also a great example of the snowball effect of bad law, because the entire potential of good enforcement is cancelled when some acts involving wildlife of illegal origin are not even an offense recognized by the law. So in order to provide you guys now a comparative view on how countries design their offenses, the research selected 3 crimes applicable to both protected and not protected species to do a cross-jurisdictional comparison. So these offenses were the illegal hunting, the illegal domestic sale, excluding advertisement, and then advertisement of illegal products, because this is with social media and internet and e-commerce, and we know that there is a lot to do in terms of criminalization of online advertisement of wildlife. So after choosing these 3 crimes, we focus on 5 core elements of penalty design. So for each one of the 3 offenses, we were trying to answer the questions for each one of the 17 countries about who can be held liable for the offense, what penalty types apply, what are the principles used to design 5 levels, what are the prison terms, and also what are the aggravating or mitigating circumstances recognized by law. And I'm gonna tell Jim just continue with the results. Thank you.
Okay, thanks, Maria. My name is Jim Wingard. I'm the legal director and co-founder of Legal Atlas, and I'm going to walk you through, at this point, the results for the for the 3 crime types that Maria just identified. But before I get started, one of the first things I want to sort of emphasize is that laws don't simply make something illegal. That's a phrase that we hear a lot, that, you know, the law is good, it's illegal to do this thing. And what we really want people to understand is that, you know, as much as the law does make something illegal, that's nowhere near the end of the inquiry. A law may say that something is prohibited, but before a law can actually be applied, it will typically say more. And what we're going to do is walk you through what those additional pieces are, the ones that Maria just mentioned, including, you know, who can be held liable, what types of penalties, et cetera. Because each one of those tools is a fairly common tool in criminal law, and they have a purpose. And that is, generally speaking, to tailor the sanction that's being applied to the situation at hand. So we're going to take a look at each one of these individually, starting with who can be held liable. And go through sort of an individual examination of you know, what the criminalizing provisions actually did. So beginning with who can be held liable, it's very common across literally all jurisdictions in the world to identify individuals, legal entities, and government officers as, if you will, targets of the criminal penalty. It isn't done consistently, and we're certainly not suggesting that there's some sort of standard out there, but there is a reason for the differentiation, because your individuals, they may be individual poachers, middlemen, you know, kingpins, tourists, you know, whatever they are single individuals. They have a particular role, and there are certain types of penalties that are likely to be applicable to them. Legal entities, it's an entirely different question. You have your hunting companies, you have your e-commerce platforms, you have all kinds of different legal entities that have a different role, and therefore, you know, likely a different sanction would be appropriate. And then, of course, government officials, corruption, things like that. So the message here with looking at this is that there are, first, practical reasons for having differential liability. One is creating different forms of liability so that you can punish different types of entities differently. In other words, you can't hold a legal entity liable with a prison term, but you certainly can with larger fines or denying them access to the resource, things like that. But the other thing that's also probably even more important is to match the liability to the impact that's observed, because each one of these actors has a different kind of impact. It's one thing to have an individual poacher out there that obviously represents a threat, but that's not the same as a poacher that's associated with a criminal network. And if your law only allows you to hold the individual liable, well, you're effectively missing the opportunity to go after the criminal network. And that's, you know, ultimately what we're looking to do. So let's take a look now at what the results tell us. And basically, when it comes to the differential liability, first I want you to take a look at the graphic, and I'm going to be talking primarily about the illegal hunting and the illegal domestic sales. The results for the advertising is really a function of the fact that it's not actually a crime type in any of the jurisdictions other than the two that we mentioned there, China and Malaysia. They're the only ones that state explicitly that advertising is actually a criminal act. So we can ignore that for the moment. But for the others, the graphic shows you when it's green, it's basically saying that you can hold that particular individual or legal entity liable. And if there's a P in the middle, that indicates that you can hold them liable, but only if a protected species is involved. And not surprisingly, of course, when it comes to illegal hunting, we see green across the board. And when it comes to illegal domestic sales, we again see green across the board, but we see a slightly greater reservation, if you will. In other words, domestic sales applies to individuals, mostly for all species, but in a few instances, of course, we have jurisdictions that limit that. When we move to legal entities and government officials, the graphic, I think, speaks for itself. We do not, generally speaking, hold them liable for illegal hunting. They're not considered, I think, traditionally a part of that particular process. When it comes to illegal domestic sales, we do see more, but in almost all cases, with the exception of one, I think Tanzania, that's limited again to protected species. And then when it comes to government officials, again, we also see relatively few jurisdictions that are singling out government officials for the role that they play. There's one last thing I'd like to say about this gap, other than the fact that, you know, the failure to tailor your liability to the type of criminal means that you're missing certain opportunities. But what I want people to understand also is that there's a hidden gap in all of this. And the hidden gap is that anytime that you have a P listed in a green square, what you're saying is that the law actually only applies to the species that are on the protected list for that particular country. So if the species is being sold at a domestic level and it's not on the protected list, that bit of domestic legislation may not apply or doesn't apply, and you would have to look to other forms of legislation to do it. It makes it more difficult. It doesn't mean that it's impossible, but you have a potential gap. Okay. The next slide is the next component, and that's asking basically the question, what penalty types apply? On the left, you have the list of penalty types, and on the right, you have a list of the objectives. Basically, the idea here is that, once again, your criminal legislation has a set of tools that they use to tailor the kind of penalty that's being applied for these different reasons. On the right, you see that you have fines. That's to deter future crime. Forfeiture, however, is to deny the benefit of the crime. Compensation, restoration, things like that are designed to repair the damage. This is a fairly common thing. Legal Atlas has done a tremendous amount of research on criminal penalties around the world, and these tend to be fairly common. They're not, the only ones that are out there, but for purposes of the research, this covers the vast majority of them. So what do the results tell us? And basically, once again, the graphic shows two things very, very clearly, and that is that you have liability for wildlife trafficking almost exclusively in the form of fines and penalties. You do have a fair amount when it comes to forfeitures, but you start to see gaps in that. You start to see jurisdictions that don't actually explicitly say anything about the forfeiture of the gains that the offender would have achieved. So, for example, what is it? I think 24% of the jurisdictions don't automatically require forfeiture. But when we move into compensation and restoration, 65% of them say nothing about compensation, and almost none of them say anything about restoration, and then of course none actually say anything about community service. I think the thing to emphasize here is that when you look at other areas of environmental law, questions of compensation restoration actually are more frequent. When you look at holding individuals liable for pollution, for example, you often see requirements that they compensate for the damage caused, that they restore the area. And we're just basically opening that up and saying, look, if polluters have to restore the damage that they cause, shouldn't wildlife criminals too? Shouldn't we be taking advantage of those as well? The next area to look at that's also very common in law is whether or not there are aggravating circumstances and whether or not there are knowledge requirements. The first, mens rea knowledge requirements, these are the typical ones: negligence, gross negligence, knowingly, intentionally, and basically it runs from being essentially less guilty to more guilty. And in the context of criminal law, you tend to see forms of liability that are more severe the more intentional the act. The same is true for aggravating circumstances that are applied to the actual act itself. The first concept is recidivism, which is just a fancy legal way of saying repeat offenses. There are also criminal provisions that will talk about either the amount or the volume. And then there is, particularly in wildlife legislation, there are ones that list out methods that are considered particularly egregious. And once again, those are considered in the context of the sanction to either increase or decrease the penalty that's applied. And going to the results, for the 17 countries that we looked at, the only tool within this set that was actually used with any kind of frequency was the question of repeat offenses. For illegal hunting, as you can see across there are only a few that don't consider it, but there are some that don't. And then, of course, when it comes to illegal domestic sales, once again, you have a few jurisdictions that are not actually considering repeat offenses, and then a few of them are also limiting it only to protected species. Okay, moving along. The next thing that we wanted to look at was, what principles were observable within the fines that we were looking at. Research tells us that these are some of the basic principles that are behind the fine levels that you will see. One is simply to deter the offense. Another would be to eliminate the financial gain, be proportionate to the harm caused, or be responsive to the offender's circumstances. So what we didn't do is say that these are the things that the criminal provisions needed to do, but we took a look at those provisions and asked ourselves the basic question, well, what is it that we're actually observing? What we didn't do is go in and list out at this point in time the actual, dollar value, if you will, simply because comparing those is not necessarily as fair, because there's a lot of elements that go into comparing how much something is worth in one economy or at one point along the trade chain versus another. So what we wanted to do was look and see, well, what kinds of principles are they actually applying within the criminal provision? And then these are the three that sort of came out of the laws. The first one being, well, are they adjusting the fines by the level of protection? In other words, if the species is a protected species, does the fine level increase? And with the exception of Cameroon and the Ivory Coast, of course, that's true. The next question was whether or not those fines were adjusted by the market value or the value of the damage caused. And here's where we begin to see less sophistication in the approach that the laws take. So we have 7 countries, it looks like, that are actually making an adjustment based on that, but the remainder don't. And then finally, were the fines adjusted by the volume, the age or the gender, some other indicator that would say that the impact of the crime was greater. And in that particular instance, there's only 2 jurisdictions that actually consider them. The rest do not. Okay, so moving beyond those principles, one of the other things that we want to highlight is the opportunity to and the ability to use other forms of liability that are outside of the wildlife law and sometimes outside of the pure criminal law. And those are the anti-money laundering laws and the organized crime laws. And just to give everybody an idea of what the difference would be, we took a look at Cameroon, and you see listed on the slide what you have as a fine for illegal hunting versus what you have for a fine if the proceeds from that hunting are then laundered. And it more than triples. And if that same event is then conducted in the context of a criminal network, it goes up again. Legal Atlas completed a review of the anti-money laundering legislation for about 110 jurisdictions recently to see how anti-money laundering laws connect to wildlife trade. That's a separate report that, if people are interested, can be accessed from our website. But it provides a deeper analysis into how those laws actually apply. But this slide, and for purposes of this research, the idea was simply to give everybody an understanding that this is substantially more powerful and allows you to not only go after the individual, but because you're talking about money laundering, you're going after the legal entity. And the same is true for your organized crime. You're actually going after your legal entities. And that changes how prosecutions occur. So, and then finally, we took a look at the UN Convention on Transnational Organized Crime, in particular its recommendation that there be a maximum prison sentence of at least 4 years as a threshold for crimes involving illicit trafficking of wildlife. And the result in that particular instance is that by and large, the countries comply or in compliance. The only one that failed for the ones that we're showing on this slide was Cameroon. And the others, of course, at least meet it, if not exceed it rather substantially. But the thing that we also want people to note in this slide in general is that the convention says nothing about what the absolute minimum should be. And in these particular instances, neither do these jurisdictions. In other words, while the maximum may be at least more than 4, say 5 years in Uganda, the court has discretion to levy a sanction or a criminal penalty that would be substantially less. So Just because they meet that as a general concept does not then mean that it's being used in that way. Okay, and with this, I will hand it back to Maria to
continue. Thank you, Jim. So yeah, before the part of the demo show of the platform, we wanted to put together 6 key messages to reinforce the results of the research. And message number 1 is that markets for illegal wildlife started to finish at the national level. So while CITES is important, domestic protection matters the most. The second message is that when we're tackling illegal wildlife trade, laws need to embrace the entire value chain from the wild to the market and also backwards, right? To follow the money from the market back to the wild. Message number 3 about key players, right? Key players in illicit trade include private business and corrupt government officials, and extending special forms of liability to them is the opportunity to address the threats that they pose, especially in the organized crime context. As a message number 4 is about the devil is in the details, right? So illegal is a simple word, but lives inside an ecosystem of legal tools. And we need to take advantage of all the potential of all legal tools available to give enforcement and prosecution the best possible chances in succeeding and having an impact. Number 5 says that many range ape states are far behind in setting fines that match the crime circumstances, the impacts, and the threats to their conservation. So a review of penalties, we felt that is a must in many countries. And last message is that focusing the blame on the lack of enforcement ignores the importance of having good law to begin with. And we also like to remember that investing in good law is always cheaper than investing in enforcement, right? The amount of resources need to prepare enforcement is huge compared with taking the law and taking time to approve law and getting a much better instrument to start with. So as rephrasing again the Legal Atlas motto, we need a smarter laws for a smarter planet. And back to Jim for the demo. Thank you so much.
Okay, thanks, Maria. At this point, I'm going to walk everybody through the Legal Atlas platform very quickly. There'll be time for questions and answers later. You can access the platform at the URL that's indicated at the top of the screen. And once you're in, we do actually require people to register, but the topics that you see are free and open to the public. They're being supported by a number of other partners, including the Arcus Foundation, and they are intended to be a resource for everybody. After you've registered, you'll see your name up in the right, so that, and then later on there'll be some more functionality associated with that. But basically from here, what you do is you go in and select a topic. The Legal Atlas platform is designed essentially to create a legal intelligence product for any topic that we can imagine. Wildlife trade, of course, is one of those. And if you go down to the wildlife trade button on the lower left and click on the info, it will show you basically 2 things. One is, what the topic is all about, what you would expect to find within it, and then on the right, you'll see who all of the partners are that have been involved in developing this particular resource today. After you've selected your topic, you will arrive at the research progress page. Every country that you see in green is a country for which we have created a framework for that particular topic. You'll notice that there's far more than the 17 that we have been looking at specifically in this particular project, and that's because of all of the other partners that have been involved. I think that we have something like 50 countries, maybe more, that are listed here now. But there's also many more countries that we have at least partial frameworks. We just simply haven't published them yet because there's ongoing research. And in fact, we've got a new project starting that will be looking at Yemen, Somali, and Ethiopia, I believe, and looking more deeply at big cats. So Clearing that screen, you can then hover over any country that has green. It'll tell you where you are on the map, of course, and then clicking on that country will bring you to this default result. It will have automatically selected the legal framework as the database. And on the right-hand side, what you will see is a fully researched set of the laws that apply to that particular topic for that country. The laws are divided between what we call the primary codes and the related legislation. This is not an indication of which laws are more important. It is only to divide them as a means of saying the laws on the top are the ones that are most related, have most of the content that you're probably looking for. But as a function of the way laws work, any of the laws that are in the related section could actually become the most important law for you. Because the case that you're looking at hinges upon a provision that's in that law and not in one of the others. So this is not an indication that the laws at the top are important and the other ones are not. It's just a function of content, which has more. Moving. There we go. Each of the laws that we put in there, we research. This is not some sort of a automated result. We actually go in and read through these laws to make sure what they contain. So when we do that, we write up very quickly how that particular law relates to the topic and create an overview. The overview does not describe the law generically. It describes only that law's relationship to the topic. So if it's a related law, like a constitution, and there's only one provision in there, we will highlight that one provision and its potential relationship to the topic. That means that for every country that you see up there, you can basically walk through those little information buttons and get a fairly rapid understanding of how the entire framework actually is set out for that particular topic. Beyond the legal frameworks that we put together, which allows you then to do any research that you're looking at specific to wildlife trade, whether that be specific to great apes or any other species. We also have some automated, what we call legal intelligence graphics. And these are basically designed to put forth patterns and messages and create research tools that should enable you to do other things. One of them is called the strategy that you see here on the screen now. And the legal strategy is not a deliberate strategy, but simply one that actually is the result of, the natural result, if you will, of all of the laws that are actually being used to regulate the topic. The reality is that in any complex topic like wildlife trade, you have laws that actually belong to different areas of law. So they may be a constitutional law or a criminal law or an environmental law. And the reality is that the kind of law that you use has an impact on what you're regulating and how you're regulating. You're not going to find typically the same kind of content in a defense and security law that you will find in your administrative law, for example. And this particular visual will allow you to then move from one country to another, looking at how they're using their areas of law generically, and it can give you an insight into some of the higher level approaches, but also gaps that may exist. In other words, some countries may be using their finance laws and other countries not. Clicking on any one of the boxes will then filter the right-hand side and it'll show you the laws that belong to that particular concept. This allows you also in the future to take a look across a category of legislation. So let's say you're interested in seeing how finance laws actually function when it comes to wildlife trade. You can go to the legal strategy, legal intelligence graphic, click on finance, and it'll filter that for you. And you can then go from country to country and do a fairly focused review without having to go and try and figure out which laws they are, etc. Another graphic is timeline. Time matters, of course, when it comes to law. And so we automatically put these, every law that comes up is put on the timeline, and you'll be able to look at that and compare that eventually to other critical moments in time, such as when that country signed CITES and whether or not they've actually done anything with their legal framework since then, or some other important legal event in the future. The next one is what we call the gap conflict monitor. As I said before, when we go in and say a particular law actually applies to the topic, we go in, we identify the provisions, and then we also take another step and we name those provisions. We create a taxonomy that says this particular provision, for example, is defining what is considered a serious crime or a minor crime in relationship to wildlife trade. And then we're able to actually go in and tag, and then this particular graphic reproduces this for us. And it has several functions, one of which, of course, is simply to see in the framework how the concept of wildlife trade is mapped out across the laws. The other is to click on any one of those and then go to the specific provisions without having to search for it. So, for example, you'll see there's a line that says Great Apes and Gibbons, and clicking on the box then takes you directly to the provision that's regulating them. And then if you click on one of the taxonomy types, it'll filter the right-hand side and it'll show you which laws contain, for example, minor crimes. The combined effect of all of this is to allow you to effectively check for gaps and conflicts that you would otherwise not necessarily know even exist. You wouldn't be aware of the fact that minor crimes, for example, exist in all of these various areas. And this interface allows us to do it very quickly. Okay. There are several other databases. I'm not going to go into to those in detail at this time, but Legal Atlas has one worth highlighting at the moment, that is the Compare database. It takes all of that taxonomy you looked at for a single jurisdiction and allows you to select one of those and then compare those provisions that relate to that taxonomy between jurisdictions. This is a tool that allows people, particularly that are involved in advocacy and legal development, to learn by comparing how other jurisdictions are doing something with a particular area of law. Okay. Right now, the Legal Atlas is being used by the various groups that you see up there on the circle, investigators and prosecutors, typically using it for the development of their strategies. Advocacy groups also doing it for a number of reasons: policy analysis, training, legal drafting, etc. Academia and think tanks are also involved. And then, treaty secretariats are looking at compliance monitoring, etc. So there's a wide variety of uses and users actually already actively involved in the system. And with that, I'll hand it over to Adam, who will manage the questions and answers. Thank you very much.
Wonderful. Thank you, Jim, and thank you, Maria, as well. Before I do my wrap-up, I'd like to invite anyone out there to ask any questions you might have about the presentation. You're more than welcome to ask queries related to Arcus as well, but you can also contact me directly with those. So if there's anything that's relevant to the content of the presentation, I think now would be an ideal time to ask those questions. We'll give you a minute or so to submit any, so please feel free to do that now if there's something that you'd like to know. Okay, it looks like we've got a question coming in, which I think Jim is going to respond to. Jim?
Okay, yeah, we have a question that's asking whether or not, in our experience, the laws of the countries are suitable for prosecution. And then a follow-up question, whether or not the info in the this information is in the website in the database. The database is designed to, I'm going to kind of answer it backwards, I suppose. The database is designed to provide us with the raw data, if you will, at the moment. It's not making a judgment call on whether or not a particular provision is suitable for prosecution. There's no way to really answer that question because when it comes to the prosecution, you have individual facts in front of you. and how those facts then play out and which pieces of the legislation apply and how they apply is simply not something that you can predict and answer in advance. You can, and this is what we've done with the report, and then also with the database, is you can identify, the vast majority of the pieces of the puzzle that are important to it, that can apply. And then you can, through a series of comparisons, begin to understand, a little bit more how those things actually, how suitable, I suppose, would be the question is. In other words, when looking at the wildlife trade criminal provisions, are you looking at a sophisticated system that actually addresses all of the points along the trade chain? And the reality is that what we're seeing is that's actually not the case. I think there's just a few countries, maybe Malaysia, that actually do a pretty good job. It may be in the future that we provide more access directly to those kinds of results, but for now, those results are in the report principally. I hope that answers the question.
Just checking if there are any other questions related to the content of the presentation. Okay, it looks like we have had some. Jim, Maria, do you have any that you would like to be able or can answer?
Yes, I can take a question here that is from Bernard Reynolds, and is saying that I'm stuck with the disconnect between the matters discussed and what is happening on the ground, right? Where people don't know what the laws are, and how can this disconnect be addressed? And super critical question, and is at the core of what we do, right? Because we always say that we want to bring law, such a complicated matter, and bring it to the hands of non-legal specialists, not attorneys, right? But regular people that is involved on the field in management issues, conservation, or even enforcement. So, but it's true that we recognize that the product itself on the platform, it requires still another step, right, to bring it down. And the only way that we understand it can be done is by start alliances and field work that brings these resources on the hands of these people through trainings, sessions, networks. And this is, for example, where we are going to start in the context of our next project in Somalia, Yemen, and Ethiopia that Jim was talking about, partnering with the Cheetah Foundation, with the idea of creating these networks of national stakeholders that can include people in media, people in academia, but is starting to bring all this legal intelligence and put it on the hands of the people. Because if we don't fill this gap, we understand that many of the actors are not prepared to come online and start using the resource without some coaching before.
I'd love to add a little bit to that, Maria, and hopefully I don't really repeat anything, but one of the people that we talked to recently said that they're actually using the platform directly in their training with customs officials, for example. So I think it's really on, Legal Atlas. It's also on all, the partners that we work with to find ways where we make literally the information that we're producing available, and find ways to make it useful in activities where those people that are on the ground that do need to know are actually then learning about it. But it is true that there is actually a tremendous deficit between, what actually applies and what's actually known or used. So,
thanks both of you. I know we've got a couple more questions coming in. Jim, there may be one for you there.
Yeah, let me.
Maria as well.
So, Whether the question is whether we're planning to do research on how laws are actually applied in different countries regarding, and yeah, that's actually literally the next step. One of the, we can't actually take that step until we've completed what we just did. In other words, we have to know what the laws are and what they say first, so that we can then compare how they're actually being complied and make, or being applied, excuse me, and then make an assessment. We've done that already in the past. We did that under a DEFRA project with the Zoological Society of London for Mongolia. And the results are consistent there with what we've heard from others, and that is that those that are engaged in the investigations and prosecutions, even though they may have any number of possible provisions that apply in a criminal context, they typically only use one or two. I can't remember off the top of my head, I don't know if you do, Maria, but how many different criminal provisions possibly applied in Mongolia, and the court records indicated that there was literally only two types of offenses that they ever actually brought to court. Mm-hmm. And then there is another organization that's actually talking to us about putting seizure and enforcement data directly into the Legal Atlas platform, so that we could then do cross-referencing. That hasn't happened yet, but that's an area that we would love to go into, and what the platform's designed to do, really. Maria?
Okay, so Jim, do you want to talk about advertisement?
Sure, okay, sure. So we have another question that's asking us, so what the way forward is for countries that have gaps on advertising laws, and that's obviously another really critical question. We know from research that we did, and also another publication that we have out, that there really are very, very few countries out there that see anything. I think there's like 7 in the world right now. One way forward, though, that might be a little bit more like low-hanging fruit, at least in my opinion, is the question of the criminalization of trade. The term just simply isn't defined, or isn't well defined. You see a fair amount of variance between the countries in terms of what you might consider to be within that concept. Naturally, in my opinion, if I were the attorney there in court, I would argue that an online sale and advertisement is, of course, trade, but it isn't defined that way, and it needs to be. Other countries are taking a different path, and they're actually amending their legislation to very specifically state that advertising, in fact, they go into some detail in order to describe exactly what that means, because even online advertising has some nuances that allow for people to escape liability. So those are the two areas. One is, amplifying our understanding and interpretation of the word trade that already exists in a lot of legislation, and then the other really is actually explicitly mentioning it. I don't know if I have anything further on that one. Do you, Maria?
I don't know. Okay, so let me wrap up. One question quickly from Susan, talking about if we plan to add Bangladesh, Thailand, and India as a part of the analysis. And the answer is not immediately. So in the long term, we really aim to cover all jurisdictions in the world, not only developing countries, but also Europe, North America. But we always depend on research projects and sponsors. To Patricia is asking if we are being able to look at laws and penalties for people who is acquiring protected species illegally, and the answer is yes. We were saying in the presentation how important is to focus and keep consistency in the criminalization of all the key activities along the value chain. So for us, those participating in the advertisement and the purchase of illegal wildlife are also deserve a lot of attention. So wanted to say also that we have been working in a global taxonomy of wildlife offenses for the past 6 months now with the Lancaster University, and we have a draft version that includes up to 400 different wildlife offenses, very detailed ones that are gonna allow us for a first time to do cross-comparison of penalties and offenses across jurisdiction in a very refined way. And purchase is a big section of the taxonomy, also uses, exhibition, scientific use of wildlife, etc. And
let me answer really quick if I can, if we have chance.
Please
There's
do,
two questions about, something a little bit more on the platform. One is, do we capture regulations, administrative rules, et cetera? And the answer is yes. We start typically with the national level legislation, but we also go after the regulations immediately. In a lot of the frameworks, you'll see regulations in there. And then the other one is asking about how we manage the fact that laws change over time. Every single part of the Legal Atlas platform has effectively a research protocol, very, very detailed behind it. One of those, of course, is how we go after the changes in legislation. And the first thing to say is that laws don't change anywhere near as often as we get that question. Many times you'll see the laws, and in fact, if you take a, we go back to one of the slides, which we won't do right now, some of those slides have been, or some of those laws have been on the books for 10, 15, 20 years. So while we do collect a lot of laws, and while laws do change, they don't change with the level of frequency that I think people imagine. That said, we've identified all of the official government websites in the world that publish law, and this is all we do. It's something that's supported both by human intelligence tasks and will be supported by machine learning and artificial intelligence as well as we go forward. So we're also not trying to collect every single law for every single topic all at once. So, we're not overwhelmed with millions of pieces of legislation. Okay.
Great. Thank you, Jim and Maria, and thank you everyone for asking those questions. I'm aware that we didn't answer them all, but please feel free to reach out to me directly if you would like to. My email address is on the Arcus Foundation website. I'd really like to extend my thanks to both Maria and Jim for their fascinating presentation, of what is clearly a very complicated issue at many levels across multiple states that varies from the individual to the network, and one that is changing rapidly as a result of technological advances. Maria mentioned how wildlife crime is not seen and thus treated in the same way as other kinds of crime. And there is clearly a need to think more carefully about how we reconcile these environmental and economic challenges, both at the levels of legal reform, as well as for those of you working directly with species on the ground and with representatives of the state who are liable for their protection. I mean, we really hope that this work might help you identify opportunities to better support enforcement and prosecution strategies, but also in the longer term, help improve policy around this complex issue, including at the global level through mechanisms like CITES and in the countries where you work. And Arcus would certainly like to continue to think about the issue and welcome ideas, perspectives, thoughts and suggestions, both about how the tools and the learning around these key messages, Legal Atlas's 6 key messages can be disseminated, but also on how these issues themselves can be addressed. So as I said, feel free to contact me directly. Please have a look at the online platform and the resources. There's a real wealth of information there, presented in ways that those of us without a legal background can engage with. So I really recommend that you do that, and that you found the presentation informative and interesting. And once more, thank you to everybody who took the time to join us today, and specifically to Legal Atlas, to Maria and Jim, for presenting the outcomes of some very, very hard work. So thank you all.
I'll also add, Adam, that for anyone else who has additional questions, please, you can connect with us not only through the email addresses that are listed on screen, but also through our social media. You can connect with us there for updates on events, for updates on other grantees, and you'll find out about the many resources that we have to share, including an extensive library of visual resources that are available for sharing among our partners. So I'll conclude then by thanking our panelists, and Adam, thank you as well. And we'll be in touch in the coming days with a link to the replay of this webinar, which will also be posted on our website, arcusfoundation.org. And I wish you all a pleasant remainder of the day. Thank you for joining us.
Thank you very much.